Welcome to the Cyber Risk Management Podcast. Our mission is to help executives become better cyber risk managers. We are your hosts. I'm Kip Boyle, CEO of Cyber Risk Opportunities.
And I'm Jake Bernstein, Cybersecurity Counsel at the law firm of Newman DuWors.
And this is the show where we help you become a better cyber risk manager.
The show is sponsored by Cyber Risk Opportunities and Newman DuWors LLP. If you have questions about your cybersecurity related legal responsibilities,
and if you want to manage your cyber risks just as thoughtfully as you manage risks in other areas of your business, such as sales, accounts receivable, and order fulfillment, then you should become a member of our Cyber Risk Managed program, which you can do for a fraction of the cost of hiring a single cybersecurity expert. You can find out more by visiting us at cyberriskopportunities.com and newmanlaw.com.
So, Kip, what are we going to talk about today?
Jake, today we're going to talk about the California Consumer Privacy Act, or as it's so often called, the CCPA.
So, Kip, as you know, the European Union's General Data Protection Regulation, which is much more commonly called GDPR, has really transformed the face of security and privacy compliance and regulation, not just in Europe, but around the world.
And we're just beginning to see those transformations. But okay, so we said we're going to talk about CCPA. You immediately mentioned GDPR, but GDPR is European, right? So is there some connection here? What is it?
There is. Either that or I just completely messed up my script, but no, there is a connection, Kip. And, certainly the European law does apply to U.S. companies. But the reason I mentioned it is that today we'll be discussing the first U.S. law that I think is really modeled after the GDPR. And it should not be a surprise that California is the first state to dramatically expand consumer protections that are related to privacy and security here in the U.S.
Well, so California was the first, I think back in I think it was 2003 or 2004, right? They were the first state in the nation to have a data breach notification law, right? So that was another first. And now today, I think, isn't it all 50 states have one?
I believe so. I mean, there might be one state that doesn't, but to my knowledge, every important state, not that they're all not important, but every state that's likely to have a lawsuits active within it has a data breach notification statute.
Right.
California was actually, California really is a leader in a lot of these areas, particularly related to technology, and that shouldn't be a surprise to anyone. After all, the modern internet, is born in Silicon Valley, and it makes sense that California would be the first to look at regulating all this. California was the first to mandate a privacy policy. That was one of their original acts there, and in fact, we'll talk about this a bit more. But the legislature in California has a lot of work to do. So let's go ahead and talk about that.
Okay. Now, it's less than a month old, right? The CCPA. And so what are the highlights of this thing, right? I mean, I don't want to read it.
Right. Well, it's long, and I don't blame you for not wanting to read it. And I think we'll hit the substantive highlights, but I think first a little bit of background is in order. Mm-hmm. So, we've mentioned the GDPR, and the GDPR just went into effect, but hopefully everyone knows it was actually passed in 2016. But it had been in development for almost 20 years, like almost as soon as they passed the 1995 General Data Protection Directive, they began immediately, they began work on what became the GDPR. So the GDPR is not new, although people think it is. So the California Consumer Privacy Act, though, is new, and it was hastily drafted and passed. And you may be wondering, well, why? Mm-hmm. And the answer is that it was put together practically overnight as a compromise solution that was made with the sponsors of a proposed initiative measure, number 170039, that was a citizen ballot measure that would have created the Consumer Right to Privacy Act of 2018. And it was, to my knowledge, quite harsh, like very, very anti-business. And one of the little interesting legal realities, at least for California, is that a citizen passed initiative that becomes a ballot measure, that becomes law, is very difficult to amend.
Well, don't they have, is it Proposition 13, which puts severe restrictions on the increase of property taxes? I think that was titled a ballot initiative.
They do. Anything that's titled the proposition is what, is one of these initiative measures, and those are simply under California's constitution, those are not easily amended.
Okay, and so is it common to see this kind of thing where a ballot initiative is set aside in favor of something that the legislature puts together?
Not to my knowledge. I think the reason this was newsworthy, aside from being kind of a topical, on point piece of news regarding privacy, this is not that common. So ultimately, what did happen, as you alluded to, is that the CCPA was put forth as a replacement for this ballot measure, and getting it actually passed was, and by the way, they did it at the last minute. It was passed the day before the deadline to remove initiative measures from the ballot.
So they must have really been, the tech industry must have really not liked the ballot initiative. Do you think that was the motivation? Yes. Okay.
That is clearly the motivation, and so anyway, here we are with the CCPA. It's honestly a mess. It's a mess internally, and it's a mess in connection when looked at more broadly with all of California's other privacy-related and security-related laws.
Okay, so now we know how the sausage was made, right? So. Yeah. So what does this actually mean, right, for consumers and businesses, and is it going to affect people outside of California?
So those are both really important questions. The first thing is to know that it's a lot like the GDPR insofar as you've got a 2-year kind of grace period, if you will. So in other words, this law won't go into, well, it's in effect now, but it won't go into,
enforcement.
Compliance won't be required is a way to look at it until 2020.
Okay, 2 years. All right.
Which is 2 years. But of course, as everyone knows who has dealt with last-minute GDPR compliance, that 2 years goes by in the blink of an eye.
Especially when you're ignoring it.
Particularly when you're ignoring it. And then I would say that, the CCPA is, of course, just the start. California is a leader in this space. California is a leader in many spaces. It's literally the 5th largest economy, behind only the United States as a whole, China, Germany, and I think Japan. So it's, California is massive. And as we mentioned, obviously, Silicon Valley is in California. So you might say, okay, so it does technically only apply to California residents, and it focuses on California residents. But it applies worldwide if you're touching California, which isn't hard to do when it's the world's 5th largest economy. Right.
And so just like GDPR follows an EU citizen wherever they go.
Sort of, yes. The GDPR is actually a little bit different. It talks about location, like where you are, whether you're a citizen or not. Whereas for California, it is kind of citizenship, residence that matters. So in any event, the CCPA is going to have worldwide ramifications for sure. It's going to affect everyone.
Okay, so even though this is a California law, I think one of the takeaways here is that the scope is at least national, if not worldwide. Okay, and then we also have 2 years to prepare for enforcement to begin, or for compliance to become effective. So, so what do companies have to do? At this point, what does it seem like needs to be done?
So with the big kind of caveat asterisks, small print that this is subject to change. Here's where things stand right now. So we've got kind of a first, something that actually is, I think, innovative and new, is this anti-discrimination component of the CCPA. And and it's broad. It's, it's not just a, protected class anti-discrimination law. That those are well established across the country in the U.S. Constitution, Bill of Rights, etc. This is a prohibition on all forms of discrimination really related to or based on data. Whether that's price discrimination based on credit score or location where you are. I mean, you think about, there's a lot going on here, or even price hikes, because let's say you've opted out of certain forms of behavioral marketing.
Mm-hmm.
Again, it's early days, but the commentators are basically saying that this component alone is going to change how the internet works if it goes through and is enforced. And the reason is that it's a direct attack on the kind of charge free. I don't want to say free services, because a lot of services that people think of as free, it's not that they're free, it's just that they don't cost you money. And
right.
That's right. So
yeah, it's that old saying that if you're not paying something, then you're the product.
Right. Exactly.
So like Gmail, like I've got a Gmail account and I've been using that for years and years, and I haven't paid a penny for that. But I think what you're saying is that information about me based on what's in my email is bundled up and sold off to advertisers and so forth. That's what you're getting at, right?
It is, and that's how all these services are supported. I mean, that's what makes Google. Everyone thinks Google's an internet search company.
No, they're the largest advertising agency in the world.
Exactly, right? There just so happens that they're powered by internet search, but make no mistake, they are an advertising company.
Right.
And
just like Amazon's a retailer. I mean, at the end of the day.
Yeah, well, Amazon's funny, right? Because it's both a retailer, but it's web services business. It's AWS. Like that is truly a separate and one of its most profitable endeavors. Anyway, that's a non sequitur.
Yeah, sorry.
Though this law will affect Amazon. Clearly.
Okay. So anti-discrimination. So this is really interesting. So, when I think about, this is called the Cyber Risk Management Podcast, right? And I've typically been thinking about cyber risks as, people who are trying to steal your digital assets and that sort of thing. And sometimes I think about it as, regulators being overly harsh on things like, data breach, reporting requirements, like only having 72 hours to report a data breach. But this feels to me like a different type of cyber risk that's coming at people, right?
It's definitely a new type of cyber risk. It goes to business models and practices. There's just no question. I mean, it is what it is. And I think that if it stays untouched, it is possible the CCPA will cause a diminishment or possibly death of a lot of these quote free services, including Gmail. And you and I both remember that there was life before Gmail and Hotmail, and you had to pay.
If I squint really hard, I think I can remember that.
It was a long time ago. Suddenly those email addresses that come from your ISP are going to look a little bit less uncommon if Gmail and things like that have to can't use advertising to support themselves. Okay,
so this anti-discrimination clause, does that mean that that we can opt out of this data trading that's going on out of our site with the information about us, or what does that mean?
So yes, it absolutely means that you can opt out. So a lot like the GDPR, the CCPA has right to access, right to deletion, right to opt out. It's all there, right? In different phrases, but it's all there, and it is just like the GDPR. It's extremely broad. It applies to all industry sectors anywhere in the world if the personal data of Californians is involved.
Wow. So a real quick question here. So if you were to, we do this a lot of times with different cybersecurity mandates, right? Like you've got HIPAA and PCI, for example, and we often will like map, like ask ourselves, what's in HIPAA that's also in PCI, right? How do these two things overlap? Have you been able, or has anybody sat down and done a CCPA to GDPR mapping yet? What would you think the overlap is?
Oh, it's probably, I mean, the answer is, well, I haven't. Someone may have. It could be a little bit of a foolish exercise today, simply because, it could be a lot of effort for nothing if the law changes.
Yeah. But I mean, if you were to guess, I mean, is this
probably
80% overlap, something like that?
75-ish.
That's still quite a bit.
It is quite a bit. I mean, obviously there's a lot in the GDPR that's very specific to the European Union and how it operates. Whereas the California law can just leave all that out and is much more focused.
So let's get to the part of the CCPA that is probably similar to GDPR, which is penalties, right? So GDPR, the penalties can be very large, right? It could be a percentage of your gross revenue. So even if you're not profitable, right, then you can still get a hefty fine. What's the situation for CCPA?
So the CCPA, uses a statutory damages model, which is pretty common in the U.S. So U.S. law and European law are pretty different in quite a few ways. One of those is damages and the need to prove harm. Pardon me. So one of the major blocking points for class action lawsuits involving data breaches over the last decade has been this idea of harm. Well, yeah, we lost all your data, but did it hurt you? Can you prove harm? Turns out there's Article 3 constitutional level, requirements to show that something is a case or controversy is where this comes from. So, but there's ways around that. And one of them is a statutory damages provision that basically says, okay, we don't know what your harm is, and we don't care. This is worth X dollars per incident or per person or whatever, and you don't have to prove harm. So California said, okay, $750 per consumer without having to prove any harm at all.
That's amazing. That is absolutely amazing to me to have that provision in there, knowing what you said earlier, which was that this law was considered a more acceptable substitute to the ballot initiative, and yet to have a no harm proven clause in here is really stunning. So
the statutory damages are pretty common. So, for example, the California emails anti-spam law, which is pretty harsh, is actually $1,000 per email. Statutory damages. So that can add up quick.
Yeah. But you can send emails all day long, right? The millions of them.
Yep. But, I think this is interesting, right? I think this is a game changer. Quick math will show just how much leverage plaintiffs' lawyers are going to have and the California AG. Let's just take Equifax, partly because it's a ridiculous, it's a huge example.
Yeah.
They lost maybe, 180 million people. If all of them were able to sue under Californian law, and that's debatable, but you'd be surprised how this works out. That would be 135 billion, as in B as in boy, $1 billion in statutory damages. Enough said. I mean, that is that's a huge number.
Yeah, that's a game changer.
It's a game changer, and we haven't mentioned it, but the law is providing a clear private cause of action for security failures. Interestingly enough, there is no inbuilt cause of action for, quote, privacy violations. So that's a major shift from GDPR, which is really, GDPR is privacy first and security as a privacy enabler.
Okay,
whereas CCPA is arguably prevention of breaches first, privacy second. And even if it doesn't read that way, the economic incentives and the enforcement powers pretty much make it that way.
Okay.
And so your next question logically is, well, what do I have to do? And guess what, Kip? It is our favorite phrase. Reasonable security measures that we've discussed, that we've discussed on this podcast many times before. So
right. Now, is there an explicit connection in CCPA to the Federal Trade Commission? Because that's kind of where we have been looking to in terms of trying to understand what reasonable is.
There's not an explicit, and California doesn't do that, right?
Okay.
They don't ever. They really, they're an outlier in terms of the rest of the country, in terms of how their code is organized, how it's written, how it's made. They're actually, in a way, kind of a combination of American English and continental European traditions. So that means it's a combination of common law and civil law. They have a lot of statutes. They're one of the few states that insists, for no obvious reason, to have a completely different set of civil rules of procedure for state courts compared to most of the states that basically use a variation of the federal rules of civil procedure. So, California is big enough to do its own thing, and so, the
all that
is,
to say, they're not going to really point to the FTC.
They're not going to directly point to the FTC, but reasonable is reasonable, and the way that our system works is that when you're in court, you're going to be pulling from everywhere you can, and that's what's going to happen.
Okay, so even though they don't make it a hard link to the FTC, then it's still okay for us to think about the way the FTC defines reasonable security measures when we think about CCPA. It
is, yes.
Okay, that's great. I mean, in the face of all this, it's nice to have that anyway, right?
It is, yeah.
Last thing we need is more ambiguity.
Right, and let's quickly run through the ways that the CCPA is like the GDPR.
All right.
You've got a broad definition of personal data. You've got transparency requirements about the use of personal data, the rights to opt out. Interestingly enough, there is a right to deletion. I don't know if it's going to look like the same kind of right to be forgotten that we're used to from the GDPR, but it's in there.
Okay.
There are deadlines to comply. There's opportunities to cure similar ideas, but there are also a number of pretty stark differences with the GDPR. One, of course, we already talked about. Just the focus is more on security than privacy. There are exemptions for smaller businesses. So if your revenue is less than 25 million gross, then this law doesn't apply to you unless there's a couple other kind of specific things relating to selling consumer data, like the number of consumers you do, or if 50% or more of your income is based on selling consumer data. So if you're smaller than 25 million and you have nothing to do with personal data, then it doesn't apply to you.
Okay.
But if you're smaller than 25 million, but you're still kind of a data analytics or marketing type company, then it probably will apply to you.
Okay.
So what else does it do? It creates some interesting financial incentives for the California Attorney General to enforce the law.
Who financial incentives for the state? Interesting. What is that?
So basically what it means is it allows the AG to sue for penalties and use that money for additional enforcement actions, which is not uncommon. What is a little bit interesting about it is that the AG basically, so in order to bring a private lawsuit, you have to alert the AG that you're going to do it. The AG then has a certain number of days, I think it's 60 days, to decide if it's going to sue instead of you, right? Then it gets to then it can go after the penalties, right? If the AG chooses not to, then you as a private citizen can move ahead with your lawsuit. What does that look like in practice? I mean, the AG is going to end up, there's no way the AG is going to keep up with the private plaintiff's bar, which is powerful in California anyway. So I don't see a major issue if you're a plaintiff's lawyer, I don't see a major issue with kind of having everything taken by the AG. The AG just can't do that.
Okay. Okay, but I mean, we could probably do a whole podcast episode on whether that's a good idea about, you know, financial incentives to the AG, and then you know, being able to preempt, you know, people who have been harmed, or, you know, at least people who've been violated.
Well, so obviously when the AG takes a case, you know, money is still going to end up going back to those people who were harmed.
Okay.
It's just going to I can almost guarantee you it was a compromise to avoid writing a blank check to plaintiffs' lawyers, because really what happens, you know, really what's going on there is, you know, a class action lawsuit oftentimes is not a very good remedy for the people who are hurt. It's a very good business for plaintiffs' lawyers, though. So, you know, that's probably what we're looking at there.
Okay.
So one more thing, this is really interesting, because we're still the USA. The CCPA specifically allows businesses to offer financial incentives, including the payment of money directly to consumers in exchange for collecting and selling their personal data.
Well, don't they already kind of do that? So like Gmail example. So like I have free use of Gmail. So aren't they kind of already giving me something of value for collecting and selling my personal data?
And I think that's the argument that people who say it's not the end of charge-free services are going to use. What may have to happen but because of the way the law is written, what you may see is, okay, you know, we have to charge $10 a month for Gmail now, right? But you know, we will pay you $10 a month to collect and sell your personal data and advertise to you.
I see.
So
right. Okay. So if you opt in, you can get a 10%, or I'm sorry, a $10 discount on the $10 price.
Right. Or put another way, that the cost is $10, but they just happen to be paying you $10 a month as well.
Right. Okay.
So we'll see. This is very speculative.
Yeah, that's not European at all, right? I mean,
that is not European. No, that is 100% American.
Yeah. Well, I don't know what I think about that being an American, but I think we can conclude that that CCPA is a behemoth. There's so much going on here.
It is. There's a lot packed into this law, and you know, the best part, the confusing part, is that none of it's set in stone at this point.
Well, why is that? I would expect that since it was passed, that, you know, this is it. I mean, why?
Well,
why do you think there's an opening for change before it becomes enforced?
Well, so one, the ability to change it was actually the point of having this passed as a California legislature law, as opposed to the ballot measure, because the legislature can go in and amend its laws easily, right?
Okay.
Whereas they cannot do that procedurally with a citizen measure, ballot measure.
Okay. So even though they passed it, they kind of passed it knowing that it was still, you know, sort of wet clay, and they could still mess with it later on.
Well, and I agree with some comments that have been made that they actually have to mess with it quite a bit. The reason is that it's not really even internally consistent, and it openly conflicts with other California, you know, privacy and security laws, like the data breach notification law, the privacy policy requirements. So there's really just there's no way to get around the fact that the legislature has a lot of work ahead of it to craft some kind of, you know, consistent, sensible framework for this topic. You know, my takeaway, my closing thoughts before we get to yours are that now that the internet is here to stay, you know, there's really no risk that the internet is going to fade away, right?
Yeah.
You know, there were some who may have thought it was a fad as recently as 20 years ago, and there were a lot of laws passed specifically to prevent liability and protect internet companies from being sued. You know, the ironically named Communications Decency Act, it gets a lot of press about this. That is the act that Backpage.com used to defend itself when it was, you know, pimping, you know, underage and underage girls and victims of human trafficking, right? But what the point of that was just to say, okay, if you're a third party, if you're a platform, then you cannot be treated as the publisher or the speaker of content posted by third parties. So
I think you'd be like a common carrier, I think is the term.
In a sense, yeah. So, and there were a lot of laws like that, right? Including in California. But I think what's going to happen now is that we're going to, I think, start to take back control. And really, we've already seen this happen, right? People have called the internet the Wild West, right?
Right. Yeah.
Well, what happened to the Wild West? It got tamed. It became civilized. And I think it's clear that the internet is becoming more heavily policed and regulated. And so it goes. The Wild West of the internet is giving way to a much more city-like urban feeling, and it's not good or bad. It's just inevitable. It's just how it is.
Okay. So we can expect more laws like this, not less. We certainly shouldn't expect that this is going to be repealed. So,
no, it's not going to be repealed. It will be modified and fixed up, but it's not going anywhere.
Okay. Yeah. Interesting. Well, so this is great. I really appreciate the opportunity to talk about this new cyber risk that our listeners are going to have to face and consider how to deal with. But it also sounds like really what we've got here is kind of a 2-year sort of spectator period, right? Because I think what you're saying is like this thing is going to come into effect, going to become enforceable, but we can expect there's going to be more changes before that happens. So it sounds like we're going to have some period of time to adjust.
We will, although I would caution listeners to not be complacent about this one, because some of these changes that are coming to the internet as a business model are seismic, right? And so one of the reasons you get 2 years is you need to figure out if your business model is sustainable and what you're going to do about it. Mm-hmm. So yes, details of execution and little pieces here and there are going to change, but I do not expect the broad concepts and requirements to go anywhere.
Okay.
Which means get started yesterday.
Right. And if you're a provider of what they call freemium, right, services, right, where there's a level of service you offer that's free, but has a reduced functionality, with the idea that people are going to pay and do upgrades, I guess this is really going to affect those people, right? Because they're probably taking some of the information that they get from people who are getting free service, and maybe even some of the people who are paying, and they're supplementing their income in a way.
Yeah, I mean, and that really depends. I think that some freemium models are advertising supported. There are other freemium models where they just want to get you hooked on a product, and then the actual business model is to sell.
Right.
Slack, for example. Slack is a good example.
Yeah. Okay. Well, so obviously this is going to have an impact on the tech scene. Okay. Oh, yes. Well, that wraps up this episode of the Cyber Risk Management Podcast. Today we talked about the California Consumer Privacy Act, or CCPA. And thanks for being here. We'll see you next time.
See you next time.
Thanks, everybody, for joining us today on the Cyber Risk Management Podcast.
Remember that cyber risk management is a team sport and needs to incorporate management, your legal department, HR, and IT for full effectiveness.
And management's goal should be to create an environment where practicing good cyber hygiene is supported and encouraged by every employee. So if you want to manage your cyber risks and ensure that your company enjoys the benefits of good cyber hygiene, then please contact us and consider becoming a member of our Cyber Risk Managed program.
You can find out more by visiting us at cyberriskopportunities.com and newmanlaw.com. Thanks for tuning in. See you next time.